In order to bring a claim in federal court, the employee is required to file what's called a charge of discrimination with the EEOC. The EEOC is the Equal Employment Opportunity Commission. The Equal Employment Opportunity Commission has what I would refer to as a gatekeeping function. Basically, the EEOC will retain jurisdiction over the complaint for a period at least of 180 days in the state of New York. During that 180-day period, the EEOC will do any number of things. One thing that can happen is nothing. Basically, the EEOC will maintain that file, and at the end of 180 days or sometime thereafter, they'll issue the employee what's called a notice of right to sue. And that notice of right to sue is basically the employee's ticket to go and file in federal court a claim of discrimination against the employer. The EEOC, however, oftentimes will do other things in reaction or as a result of an employee's filing. One of those things is investigate. They have an investigative arm that has representatives that will inquire of both the employee and of the employer of the existence of records, for example, that could support or refute a claim. They may ask for affidavits or witness statements in order to determine whether there's some valid claim there. Absolutely, an employer should have representation if in any way, shape, or form they're asked to respond to a request from the EEOC for further information. A, you want to make sure that you're complying with whatever it is that's being asked of you, and B, you want to make sure that you're on point and accurate in what you're providing. But finally, you want the attorney to be able to, and what we would do for you is present it in a way that shows that you did not engage in the alleged discriminatory behavior. The other thing that the EEOC can do, and which is really a critical function of the EEOC, is to mediate the case. What that means is they try to seek a resolution, a settlement, if you will, with the employee before the employee sues in court. And so the EEOC does serve the function of trying to minimize the number of cases that actually end up being filed in court. And they do that by approaching the case early on in the form of a mediation or a settlement. In terms of a mediation or a settlement, the employer absolutely should retain an attorney. One of the things that we do at Gould Berg is we always evaluate what your possible exposure is. That's critical for you as an agency, as an employer going forward in these agency situations. You don't want to end up saying, no, absolutely, I will not settle with this employee, and you end up finding out that after 3 years of litigation, it's cost you not only a lot in attorney's fees and costs to defend that action, but now you're facing some type of potential damage award, which, depending on the claims the employee is bringing, could very well reach a six-figure range. So there are serious ramifications if you don't have adequate representation at the beginning to advise you as to whether there's a cheaper, less expensive, more effective way to resolve the case. The EEOC can be a form of resolution for you in that sense, and certainly having attorney advice at that point in time is critical so that you can avoid the expenses that you would otherwise undergo if you didn't have the appropriate advice from the start.